So a very warm good morning to all of you. I hope all of you are doing great. So let's start today's discussion. Now, आज हम लोग बात करने वाले हैं MP 2019 फेज 1 शिफ्ट 2 के क्वेश्चन पेपर के बारे में. Yesterday we have discussed some of the questions from MP shift 1 shift 2 phase 1 question paper. जिसमें we have discussed somewhere more or less around 20 क्वेश्चंस और आज का जो हमारा डिस्कशन है वो उससे आगे होने वाला है. अगर अभी तक आपने हमारे चैनल को सब्सक्राइब नहीं किया है तो प्लीज जाके हमारे चैनल को सब्सक्राइब कर दीजिए एंड डोंट फॉरगेट टू प्रेस द बेल आइकन so that whenever me or any of our faculty members are coming live you will get a notification. Good morning Harshvardhan ji, good morning to you. Now moving further, if you haven't enrolled till now for MP Civil Judge Prelims Crash Course, do check it out. Link is in the description box. Now, let's start today's discussion. So here, the first question for the day is question number 21. Question number 21 क्या बोल रहा है? A suit for declaration in respect of public nuisance under section 91 of CPC, that is Code of Civil Procedure, can be instituted by. Option A बोल रहा है an individual without the leave of the court. B बोल रहा है an individual with the leave of the court. C, two or more persons without the leave of the court. And D option is stating two or more persons with the leave of the court. Question number 21. What should be the correct answer? Yes, just let me know. A suit for declaration in respect of public nuisance. A suit can be instituted by an individual without the leave of the court, by an individual with the leave of the court, two or more persons without the leave of the court, and two or more persons with the leave of the court. So what should be the correct answer? Just let me know. Yes, its correct answer will be D for Delhi. That is two or more persons with the leave of court. Now here, if you remember, if you will read your particular section 91, 21 ka, yes, Harshvardhan ji, D is the correct answer. If you will read section 91 of CPC, it is simply stating in this section, in this particular provision, when two or more persons are, even though they haven't suffered any special loss, even though they hasn't suffered any special loss, these people can file a suit in respect of public nuisance with the leave of the court, right? Next question. Next question is your question number. Next question will be your question number 22. Question number 22 क्या बोल रहा है? Just a second. Question number 22. 22 is simply stating dismissal of a suit by a court, dismissal of a suit by a court under section order 17 rule 3 of CPC. The only remedy available to the plaintiff is A, file an application, B, application under section 151 of CPC, C, application under order 9 rule 9 of CPC, and D, all of these. So which of the following remedy is available to the person? That the first remedy they are talking about an appeal. Second remedy, application under section 151 of CPC. Third remedy is application under order 9 rule 9 of CPC, and D is stating all of these. So remember, firstly we have to understand what order 17 is talking about. Order 17 is talking about your adjournment, right? So order 17 rule 3 के अंदर which of the following remedy is available? So its correct answer for this particular question, your correct answer will be an application under order 9 rule 9. C is your correct answer, right? I hope it is clear to you. So C is going to be your correct answer under order 9 rule 9, right? Now let's move towards next question. That is your question number 23, right? What question number 23 is stating about? Let's see. Let's have a look of this question. Suit filed on 2011-2012, and it has been specifically pleaded that the cause of action arose on 6/10/2012. Now, some of you might be thinking that, sir, why you are using pen today? It is creating problem. but I'm using pen just to tell you a few things that is important. Here you have to remember all the dates which have been mentioned in the suit, in this particular problem very much clearly, that the suit has been filed on 2011-2012, and it has been specifically pleaded that the cause of action arose on 6/10/2012. Defendant appeared without written statement, that is WS. He filed an application under Order 7 Rule 11. Order 7 Rule 11 means he is talking about rejection of plaint. He is talking about specifically rejection of plaint, right? Order 7 Rule 11, right? Now, so he has filed the application for rejection of plaint. Now, on the ground that the suit is barred by limitation, state what is the correct legal proposition. Option A, application under Order 7 Rule 11 is not maintainable because written statement should be filed firstly. Option B, that is plaint shall be rejected because the suit is barred by law of limitation. Option C, dismissed of application will be proper. Objection could be decided without recording evidence of the parties. D, application should be allowed because plaint does not disclose correct cause of action. So what should be the correct answer for question number 23? Yes, 23. If you can read this particular question properly, they are simply stating that a particular party, defendant, without filing WS written statement, pleaded about rejection of plaint under Order 7 Rule 11, stating that this particular case is barred by law of limitation. So what should be the correct proposition? That dismissal is not maintainable, plaint shall be rejected, dismissal of application will be proper, objection could not be decided without recording evidence of the parties, and D, application should be allowed because plaint does not disclose correct cause of action. So for question number 23, for your question number 23, the correct answer will be C. C for Calcutta, that is dismissal is proper. In case if a party wants to reject the plaint, here if you want you can write it somewhere in your note copy. Rejection of plaint does not require what it is not required, does not require a WS, that is written statement. So if you want to go for an application of rejection of plaint, it does not require any written statement, has to be filed first. I hope it is clear to all of you. Now let's move further. Let's move towards next question. Your next question is question number 24. 24 क्या बोल रहा है? A suit was repeatedly fixed by trial court for examination of the defendant witnesses, but the said opportunity was not availed by the defendant. Therefore, on 18/11/2016, where neither the defendant nor his counsel has appeared, the trial court has proceeded ex parte and heard the final arguments and reserved the case for judgment on 28/11/2016. The defendant has filed an application under Order 9 Rule 7 read with Section 151 of CPC, which is, what will be the correct answer? Maintainable. A is saying maintainable, B is saying non-maintainable, C is saying matter of discretion of the court to accept or not, and D, matter of inherent power of the court to accept or not. So what should be the correct answer for question number 24? If you can closely follow up question number 24, question number 24 came up with two things majorly. That firstly, though, the party was not appearing continuously, the defendant was not appearing continuously, so the court decided to the court finally decided the matter ex parte, but before passing the judgment, the court has reserved the judgment and decided a date of judgment. Now, before that particular date of judgment, under Order 9 Rule 7 and read with Section 151 of CPC, that particular party, defendant, filed an application for what? Under Order 9 Rule 7. So what will be the correct proposition? So its correct answer will be that this particular application under Order 9 Rule 7 is not maintainable, right? Because the defendant has not availed the opportunity which has been reasonably given to him. I hope this particular question is also clear to you all. Now, let's move further. Let's discuss question number 25. Next question, that is question number 25. 24, Harshvardhan Gautam ji. No, Harshvardhan ji, D is not the correct answer. Its correct answer will be second, B, the Bangalore. That is not maintainable. It is not maintainable. Question number 25, which comes in the purview of formal defect, which comes in the preview of formal defect for withdrawal of suit under Order 23 Rule 1 subclause 3 of CPC. A, want of notice under section 80 of CPC. B, confusion regarding identification of suit property. C, improper valuation of suit. And D, all of these. Which of the following can be considered as formal defect under Order 23 Rule 1 subclause 3 of CPC? So they are stating want of notice under section 80 of CPC, then confusion regarding identification of suit property, C, improper valuation of suit, and D, all of these. So here, if you people are aware that section 80 of CPC is talking about notice in the cases of suit against government, notice in the cases of suit against government, right? Suit against government, right? So what should be the correct answer for question number 25? What should be the correct answer for question number 25? Just let me know quickly. What should be the correct answer? Question number 25. Yes, its correct answer will be D. That is all of the above. D, that is all of the above. All of these are the ground of considering the formal defect in the suit. So its correct answer will be D, right? I hope it is clear to you all. Now let's move further and let's discuss next question. Yes, Harshvardhan Gautam ji, 25 ka D is the correct answer. Next question is your question number 26. That is, now this particular question is the question from Transfer of Property Act. Transfer of Property Act. What this question is stating directly, this question is stating that transfer of property of immovable property in exchange of price paid or promised or partly paid or partly promised is called. Transfer of ownership of immovable property in exchange of price paid or promised or partly paid or partly promised is called. What it is called? Mortgage, lease, sale, exchange. सीधा question है, direct question है. It is quite easy to understand. So its correct answer will be sale. Right? Its correct answer will be C for Calcutta, that is sale. I hope this particular question is clear to you. Now let's move further. Let's move towards next question. 26. Yes, C, sale is the correct answer, Harshvardhan ji. Now let's move further. Let's discuss the next question. Question number 27. Question number 27, what it is stating that, just a minute. Yeah. A gives a lakh of rupees to B, reserving himself with B's assent the right to take back at pleasure rupees 10,000 out of the lakh. The gift in respect of rupees 10,000 is. Here, if you can closely follow up the question. So in the question, they are not asking that what is the validity of the gift of rupees 1 lakh. They are not asking the validity of the gift of rupees 1 lakh. Rather than they are asking the validity of the gift of rupees 10,000. So its options are valid, void, is in force, and voidable. What should be the correct answer? Valid, void, is in force, and voidable. What should be the correct answer for question number 27? Yes, the gift of rupees that 10,000 will be void in nature. So its correct answer will be B for Bangalore. I hope it is clear to all of you, because if you will read the second last chapter of Transfer of Property Act, that is talking about the transfer of property in form of gift, they are simply stating that a gift with the right of reserving to take back is void. So its correct answer will be your B option, that is void, right? Next question. Question number 28. Improvements to mortgage property is provided in which of the following section of Transfer of Property Act? Improvements to the mortgage property, improvements to the mortgage is provided under Transfer of Property Act ka which section? So what should be the correct answer? Your options are A, section 63, B, section 63A, C, section 65, and D, section 65A. What should be the correct answer? Improvement of mortgaged property is provided in which of the following section of Transfer of Property Act? 63, 63A, 65, 65A. What should be the correct answer? Yes. Question number 28. So this particular term is defined like improvement to mortgage property is defined under section 63A. Next question, question number 29, right? 29. In absence of contract or local law or uses to contrary, a lease of immovable property for manufacturing purpose shall be deemed to be A, for 5 years, B, from year to year, C, from month to month, D, for a reasonable time period. Ankita Gupta ji, 28 ka B. Yes, Ankita Gupta ji, 28 ka B is the correct answer. 29. In absence of contract or local law or uses to contrary, a lease of immovable property for manufacturing purpose shall be deemed to be A, for 5 years, B, from year to year, C, from month to month, and D, for a reasonable period. So its correct answer will be B for Bangalore. That is from year to year. From year to year, right? Question number 30. A lease of immovable property from year to year or exceeding 1 year can be made only. Question number 30. What they are saying? Yes, Harshvardhan Gautam ji, 28 ka B is the Bangalore is the correct answer. Question number 30. A lease of immovable property from year to year or exceeding 1 year can be made only. A, before notary, B, executed before magistrate, C, agreement made by the parties, and D, by a registered instrument. A lease of immovable property from year to year or exceeding 1 year can be made only. A, before notary, B, executed before magistrate, C, agreement made by the parties, and D, by registered instrument. Question number 30. Its correct answer will be D, that is by registered instrument. Question number 31. What is the effect of holding over? 30 ka yes, D is the correct answer. Ankita Gupta, Harshvardhan, both of you are correct. 31. What is the effect of holding over? Holding over under section 116 of Transfer of Property Act, it is talking about holding over. The lease becomes illegal. B, the lease is renewed. C, the lease becomes extinguished. And D, the lease becomes void. What is the effect of holding over? A, the lease becomes illegal. B, the lease is renewed. C, the lease becomes extinguished. And D, the lease becomes void. Question number 31. Its correct answer is the lease is renewed. What is the meaning of holding over? Like suppose the notice of termination has been given, notice of determination of lease has been given to the opposite party. But after that, getting that notice, the opposite party continues to take possession of that leased property and started payment of rent. And the person who is the lessor, who has given that property on lease, started accepting that rent. So it will be considered as holding over. Its effect will be that the lease is renewed. Question number 32. Which section of Transfer of Property Act is related to oral transfer? Which section of Transfer of Property Act is related to oral transfer? Direct question hai, quite easy to answer. Section option A, section 8, option B, section 9, option C, section 10, and option D, section 11. Which section of Transfer of Property Act is related to oral transfer? Section 8, section 9, section 10, section 11. What should be the correct answer for this question? 32. Its correct answer is section 9. Next question. This is the question from law of contract. The first question of law of contract. Question number 33. A promise to pay time barred debt. a promise to pay a time barred debt is dash. A, not enforceable. B, enforceable at the discretion of debtor. Yes, Harshvardhan Gautam ji, 32 ka B is the correct answer. Yes, you are correct. Now, question number 33. A promise to pay a time barred debt is A, not enforceable. B, enforceable at the discretion of debtor. C, enforceable. And D, none of these or none of the above. So what should be the correct answer for question number 33? What should be the correct answer? That a promise to pay a time barred debt. Question number 33. Its correct answer will be C, Calcutta. Yes, that is enforceable. Right? A promise to pay time bar debt is enforceable. Section अगर आप closely read करेंगे तो your section 25 is talking about a promise to pay time bar debt. ठीक है? Next, question number 34. Where both of the parties to an agreement under a mistake as to a matter of fact essential to the agreement. Yes, then the agreement will be A, the agreement can be enforced. B, agreement cannot be enforced. C, agreement is void. D, agreement is voidable at the option of aggrieved party. When both of the parties to the agreement are under a mistake of fact. Okay? Then the agreement can be enforced, cannot be enforced. Agreement is void. Agreement is voidable at the option of aggrieved party. Question number 34. Its correct answer will be C for Calcutta. That is, agreement is void in nature. Right? Next question. Question number 35. When the agent contracts without disclosing name and existence of his principal, in such a case, on knowing the principal, the third party may file a suit against A, principal alone, B, agent alone. अंकिता गुप्ता जी बोल रहे हैं 33 का यस, 33 का सी इज द करेक्ट आंसर अंकिता जी. नाउ ऑप्शंस आर ए प्रिंसिपल अलोन, बी एजेंट अलोन, सी either against agent or against principal or both, D, none of these. Question number 35. Where the agent does not disclose the name. 34 Harshvardhan ji, yes, C is the correct answer. 35. When the agent does not disclose the name of the principal, in such case, after knowing the name of the principal, the third party may file a suit against both, either the agent or the principal or both. So its correct answer will be C for Calcutta. 35 ka correct answer is C. 36. Active concealment of a fact is associated with. Active concealment of a fact is associated with A, coercion, B, fraud, C, misrepresentation, and D, mistake. Active concealment of a fact is associated with A, coercion, B, fraud, C, misrepresentation, and D, mistake. It's a straight question. Its answer will be B for Bangalore. That is fraud. Active. Maniac Grover ji, 35 ka C is the correct answer. 36. Active concealment of a fact is associated with. So it is associated with fraud. Bangalore, B. 37. Question number 37. Yes, Harshvardhan Gautam ji, Maniac Grover ji, 36. B is the correct answer. 37. The delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, the goods shall be returned or otherwise disposed of according to the direction of the principal delivering them, according to the direction of the person delivering them, is known as A, guarantee, B, bailment, C, indemnity, D, none of these. Guarantee, bailment, indemnity, none of these. So if you people have read the contract of bailment, you will be in the position to know its correct answer will be B for Bangalore. That when a person delivers some goods to another for a specific purpose and the goods shall be returned or disposed of as per the direction of the person who has delivered the goods, it is called contract of bailment. Question number 38. Yes, Harshvardhan Gautam ji, 37 B is the correct answer. Ankita Gupta ji, 36 B is the correct answer. 38. A promises to drop a prosecution which he has instituted against B for robbery, and B promises to restore the value of things taken. The agreement is A, legal and proper, B, void, C, voidable, D, none of these. A promises to drop the prosecution against B, which he has instituted against him for robbery, and B promises to restore the value of things taken. The agreement is A, legal and proper, B, void, C, voidable, D, none of these. Question number 38. Its correct answer is B for Bangalore, that is void. If you have read section 27, 28, 29, 26, you will be having a very good idea. All of these sections are talking about the transactions where an agreement is void. So an agreement restraining a person from legal proceeding is void in nature. So its correct answer will be B for Bangalore. Yes, Harshvardhan Gautam ji, 38 ka B is the correct answer. Next question, question number 39. A promises to deliver goods to B on a certain day at a certain time on the payment of rupees 1000. A dies before that date. Here you have to read the nature of the contract. You have to understand the nature of the contract by reading question number 39. A promises to deliver goods to B on a certain day at a certain time on the payment of rupees 1000. A dies before that day. A, the contract is void. B, A's representative are not bound to deliver goods to B. C, B is not bound to pay rupees 1000 to A's representatives. D, A's representative are bound to deliver the goods to B, comma, B is bound to pay rupees 1000 to the representatives of A. So 39, its correct answer will be D for Delhi. The reason behind, here you have to understand question number 39. This is not a contract of personal skill. यहाँ पे A की कोई personal skill involved नहीं है. A has merely promised to deliver the goods. So its correct answer will be D for Delhi, right? Next, question number 40. Maniac Grover, 39. Yes, D is the correct answer. Question number 40. An agreement entered into with free consent and lawful, but with inadequate consideration, then such an agreement entered into with free consent and lawful, but with inadequate consideration, then such agreement word they haven't mentioned in the question paper, so I also haven't mentioned that thing. A, unlawful, B, lawful, C, void, D, voidable. Unlawful, lawful, void, voidable. An agreement entered into with free consent and lawful, but without adequate consideration or with inadequate consideration. Yes, Ankita Gupta ji, 39 ka D is the correct answer. For 40, the correct answer will be B. B for Bangalore, that is lawful. I hope it is clear. Question number 40 to all of you. Question number 41. Now, this is the first question of a Specific Relief Act 1963. Specific relief can be granted. 41 ka option A is stating for the purpose of enforcing individual civil rights, B for public interest litigation, C for enforcing penal laws, and D all of these. Question number 40 नहीं हर्षवर्धन गौतम जी, question number 40 को आप closely पढ़िए. The language is stating here, even though the consideration is inadequate, but the object behind the contract was lawful, the free consent was there, right? And the consideration was lawful. So it hardly matters, even if the consideration is inadequate, but it is lawful and given with free consent, then the particular transaction will be considered as valid and the contract will be lawful, right? Harshvardhan ji. 41, yes, Maniac Grover ji is the correct answer. 40, Ankita Gupta ji saying B. Yes, Ankita Gupta ji, B is the correct answer. Question number 42. Section 20A was inserted into Specific Relief Act in respect of special provision of contracts which are A, infrastructure project, B, land agreement, C, mergers and acquisitions, D, none of these. Question number 42. यहाँ पे देखिए section 20A has been added by the Amendment Act of 2018. Section 20A, this particular provision was added by 2018 Amendment Act. 2018 Amendment Act, right? So section 20A, it is talking about your infrastructure project. It is talking about infrastructure project. So 42, its correct answer will be A for Ahmedabad. I hope it is clear to all of you. Now let's move further towards our question number 43. Okay, is there any confusion in question number 42? I hope it should be clear. If you can read 2018 Amendment Act, you can easily get the answer of this question, right? Question number 43. Declaratory decree is binding on. 42 ka yes, Harshvardhan Gautam ji, A is the correct answer. Declaratory decree is binding on A, parties to the suit, B, parties and their representative claiming through them, C, trustee, and D, all of these. Yeah, all of the above. Question number 43. Declaratory decree is binding on only on parties to the suit and their representative claiming through them, C, trustees, and D, all of these. If you can read section 34 of Specific Relief Act, you can get the answer. Its answer will be D, all of these. Declaratory decree is binding on the parties, their representatives, and trustees. Question number 44. Which of the following is not essential condition for the applicability of section 8 of Specific Relief Act 1963? Which of the following is not the essential condition for the applicability of section 8 of Specific Relief Act 1963? A, article must be movable property. B, article must be in possession and control of the defendant. C, the defendant must be owner of the property. D, the plaintiff must be entitled to the immediate possession of article. Now, those who have attended the previous classes when I was discussing 2019 phase 2 ka question paper, there I have discussed section 8 in detail, section 8 of SRA in detail. So if you if you people remember that particular provision, section 8, you will be able to answer. Question number 44, its correct answer is that it is not always necessary that the defendant must be the owner of property. So its correct answer will be C for Calcutta. Question number 44, its correct answer is C. Question number 45. Question number 45. Which of the following facts is not correct under section 14A of Specific Relief Act? Which of the following fact is not correct under section 14A of Specific Relief Act? Again, section 14A was also added by by Amendment Act of 2018, Specific Relief Act Amendment Act 2018. ठीक है, options are A, the report of expert shall form part of record. B, the opinion of expert may not form part of record. C, the court may require or direct any person to give relevant information to expert. D, the expert shall be entitled to such fees, cost, or expense as the court may fix. Question number 45. What should be the correct answer? Nahi, Ankita Gupta ji. 44 ka correct answer will be your C, right? The defendant should have the possession of movable property, possession and control. They are not talking about that he should be the actual owner, defendant, right? Question number 45. So its correct answer is B for Bangalore. That is, the opinion of the expert may not form part of record. This particular statement is wrong. यहाँ पे देखिए हमसे ये पूछा गया है, which statement is not correct? Which statement is not correct? That's what they are asking. So its correct answer is B for Bangalore, right? The opinion of the expert shall always form part of record. Next question, question number 46. In a suit for a specific performance of contract in which compensation has not been claimed, fresh suit for compensation is A, is maintainable, B, is barred, C, is maintainable if filed within limitation, D, none of these. Question number 45, Ankita Gupta ji is saying B. Question number 45, its correct answer is yes, B for Bangalore. Question number 46, what should be the correct answer for 46? In a suit for specific performance of contract in which compensation has not been claimed, the fresh suit for compensation is maintainable, B is barred, C is maintainable if filed within limitation, and D, none of these. So 46 ka correct answer is B for Bangalore, that is barred. if you can read section 40, it is stating payment of compensation in lieu of or in addition to specific performance. So they are simply stating that if a party hasn't claimed for compensation in the cases of a specific performance of contract, then a fresh suit for compensation or damages shall not be entitled by the court. Question number 47. Now, question number 47, this particular question is relating to your Limitation Act, where the prescribed period for any application is expiring on a holiday. The application. Question number 47, section 4 of Limitation Act की सीधी लैंग्वेज उठा के यहाँ पे रखी हुई है. Question number 47, where the prescribed period of limitation for any application is expiring on a holiday, the application A should be made a day prior to holiday. B may be made on the day when the court reopens. C may be made within 30 days of reopening of the court. D may be made on any day after the court reopens. Yes, 46 ka correct answer is Ankita Gupta ji. Its correct answer will be B, that is the suit is barred. 47, what should be the correct answer? So its correct answer is B for Bangalore, that the suit can be instituted, may be made on the day when the court reopens, right? This is what is stated in section 4. Question number 48, when suit for which no period of limitation is provided elsewhere in the Limitation Act 1963, the period for filing a suit is 3 months from the date when the right to sue accrues. B, 1 year from the date when the right to sue accrues. C, 3 years from the date when the right to sue accrues. D, 12 years from the date when the right to sue accrues. Right? Question number 47, yes, Harshvardhan Gautam ji, B is the correct answer. Question number 48 में देखिए, all of us are aware that there is a provision of 3 months and 3 years. So some of you might get confused. हम जल्दी में कई बार क्या करते हैं, हम क्वेश्चन को प्रॉपरली नहीं पढ़ते and we mark the answers. So its answer is 3 years. याद रखिए, its correct answer will be 3 years, not 3 months. Both A and C options are using 3, but here it is 3 months, here it is 3 years. So its correct answer will be C, that from the date when the right to sue accrues within 3 years from that date, right? Correct. Chaliye, next question number 49. Legal disabilities are A, minority, B, insanity, C, idiocy, and D, all of the above. Legal disabilities are minority, insanity, idiocy, and all of the above. What should be the correct answer for question number 49? If you have an overview of Limitation Act, you will be in the position to answer this question, right? Minority, insanity, idiocy, and all of the above. Question number 49, its correct answer will be D for Delhi, that is all of the above. When a person is minor, idiot, or insane, that particular person cannot file a suit. So all these are legal disabilities. Maniac Grover ji, yes, 49D is the correct answer. Harshvardhan ji, 49D is the correct answer. Question number 50. What is the limitation for foreclosure? What is the limitation for foreclosure? Question number 50. A, 1 year, B, 3 years, C, 12 years, and D, 30 years. Yes, limitation for foreclosure. 1 year, 3 year, 12 years, and 30 years. Question number 50. What should be the correct answer? Just let me know quickly. What should be the correct answer for question number 30? (49) Ankita Gupta ji is saying D. 49, yes, D is the correct answer, Ankita ji. Yes, question number 30. What should be the correct answer? Its correct answer is 30 years. So the limitation period for foreclosure is 30 years. याद रखिए, in the cases of all the cases of immovable property except foreclosure, it is 12 years. Yes, Harshvardhan Gautam ji, 30 years. D for Delhi is the correct answer. So that is how we are going to stop here for the day. If you people actually enjoyed the video, don't forget to like the video and subscribe to the channel, and don't forget to press the bell icon. Tomorrow we are going to meet again Ankita Gupta ji R. Ankita Gupta ji, R, what do you mean by R? I'm not able to understand. If you people are having any confusion, don't forget to drop it in the doubt session, like in the comment section. Thank you, Harshvardhan ji. See you all tomorrow in the next class. If you haven't subscribed till now for the MP Civil Judge Prelims Crash Course, just do check it out. Link is in the description box. Thank you all. See you in the next class.